Hello again, my name is Jo Rogers and I'm the founder of Navistar Legal. Welcome back to our investment series. In this video, I'm going to give you some guidance about how to put some of the requirements we've been discussing into writing. Our other videos focusing on making decisions about investment and then staying in control of your company at both the shareholder and director level once you received that investment. Well, obviously this is at a high level view. There is so much more I want to share with you, but as always, there are exceptions to most of these rules. In my opinion, these issues point to an art and not a science. So you'll need to use your own intuition, your own understanding of business, and your own common sense in order to gauge what fits and feels right for your business. Today, we're going to look at how you can put all of this into writing, and therefore the important documents to consider when dealing with investors. Let's start first with some basics. Why do you need to put anything into writing? Well, from my perspective, in an ideal world, every business would have every agreement in writing, signed by all the parties, stored appropriately, and updated upon renewal. But in the real world, there may be a few loose ends. So if you need encouragement to get records in order, then just know that a strong client base is a really strong reason for people to buy a company. So it's worth paying some attention to if you decide you want to sell at a later stage. An agreement doesn't necessarily have to be in writing to be legally binding, but getting something on paper is a simple way to stop issues in the long run. Putting everything into writing gives everyone the opportunity to discover any gaps in your understanding and gives you a basis to work from, ask questions, and discuss the what ifs. This reduces the likelihood of disputes, broken promises, and severed relationships. As well as providing clarity, it acts as a record of what was agreed and evidence if you need to go to court. So take some action now. You can download our contract sheet so you can have a list of all your agreements in one place. Let's start with the first agreement that you will need to provide to investors. That is the non-disclosure agreement, or the NDA. Before you provide any details about the company at all, i.e. your marketing plans, your expansion plans, your financial plans, you will definitely want to protect yourself against any unauthorized disclosure of your trade secrets with a non-disclosure agreement. In this agreement, investors are obligated to keep the information that you're providing to them secret and confidential. Especially if they're investors that have invested in other similar companies, it will become imperative that your plans are not shared or used to improve your competition. Usually the NDA will be provided to an investor before they receive the full details of the investment or plans with respect to the business. The NDA will make sure that potential investor uses only the information for the purpose of making his decision about the investment and no other reason. The agreement is usually one-sided, which means only the investor is under any obligation to keep things confidential, which makes sense because they're not sharing information with you. The NDA will provide for certain limited situations where an investor might be required to disclose information, but these are really limited to being, if there's a matter of law or if they provide it to their professional advisors or employees who are supporting them in completing the investment. Sometimes you're looking for a large investment from several investors, so you might want a subscription agreement. Imagine that you want to raise £2 million investment. No one individual may want to put up the full amount, they might not be able to, but if you get each investor to sign up on the condition that if everybody agrees to it, then their money will be committed, that's what a subscription agreement for. It's usually for larger sums of money, but they can be useful to get people to sign on the dotted line to show their commitment to you, at least until you can get everyone else to invest. Now let's look at the shareholders agreement and the articles of association. A shareholders agreement can be made between all of your shareholders of your company or just some of them. Even people who are not shareholders can be a party to your shareholders agreement if that's appropriate. A shareholders agreement can be made at any time during the lifetime of a company, but it's usually made when a new company is set up or new investors come on board. Key issues in a shareholder agreement can include the overall business strategy, how management decisions are taken, who has responsibility in certain areas, what will happen if the business needs to raise additional financing. You may already know this, but as a shareholder, even if you don't have a shareholders agreement, you are still bound by the Articles of Association. A company's articles of association typically set out the basic rules, the processes and procedures for your company. Like most businesses, you may never have read your articles of association, and they're often forgotten. That's not really a problem when you own 100% of the business or you're the sole director. However, when that changes, you have to start considering what is in those agreements. They contain similar things, but there are some differences between having a shareholders agreement and articles. Unlike the shareholders agreement, the articles are a public document. They're actually open to public inspection at Companies House or the company's registry. Therefore, if you want to keep certain things secret, you will want to put it in the shareholders agreement. A shareholders agreement is a private contract between the parties for which the general public have no right to see. On the other hand, the articles can be altered at any time by what's called a special resolution of the members. This means that 75% of the shareholders can vote to change them. A shareholders agreement, on the other hand, cannot be amended except with 100% of everybody needs to agree to that change. Generally, if you do have a shareholders agreement, you will also want to make sure that exactly the same terms are reflected in the articles. You don't want it that your shareholders agreement allows for, let's say, the directors to have a meeting with 4 directors present, but your shareholders agreement allows for a meeting to continue with just 2. So I'm going to suggest an action here. I'm going to suggest that you go and find your articles of association and at least have a skim through them. If there's anything that stands out or that you don't understand, highlight those articles. If you have a shareholders agreement, take some time to see whether the mechanism is in the same for both the articles and the shareholders agreement. We discussed in our other videos the importance of the role of a director. If you're bringing other directors on board, you will want them to commit to certain roles and responsibilities within your company. This means you may want them to be aware of their director's duties as well in a director's consultancy agreement. Each of these can be put into this service agreement, and if a new investor is coming on board, you want to think carefully about whether this director's agreement that they might want to put in place would impose too many onerous obligations on you. Finally, we look at minutes and resolutions, and these are often forgotten by people. If you don't have a company secretary, board minutes and resolutions are important documents. These demonstrate that the directors or the shareholders have approved certain decisions, and they're a record of that fact. The minutes themselves are usually in a pretty standard format, and you'll find the type of resolution that you need will be set out in the articles, which is why they are so important. And that brings us to the end of this investment series. I hope that you've got an understanding of the documents required for your investment, how you can maximize your efficiency by getting some systems and processes and procedures put in early on. As I said, there's so much more to know about this, but I hope that you've come away with some key actions and a greater understanding about what you may need to do more research. I wish you all the best in engaging your investors and getting your investment, and I look forward to meeting with you soon.